Next witness
Thank you so much.
is Lynette Labinger. Hi, Lynette, are you with us?
I am. I'm right here.
Welcome to House Judiciary. You have the floor. Please try to keep it brief.
Thank you very much. I'm speaking on behalf of the ACLU of Rhode Island. While hate crimes deserve condemnation, the ACLU of Rhode Island is opposed to passage of H6147 for several reasons. In expanding the coverage of the Hate Crime Sentencing Act, H6147 would make it easier to find a hate crime based solely on the written or spoken word and without a direct finding of animus or target. Section 1 would amend the Hate Crime Sentencing Act in several ways. First, it would alter the standard for determining the existence of a hate crime by providing, as your last speaker mentioned, mixed motive, that one can be established whenever any person or group is a target of a crime, not just in whole, but also in part, on the basis of a protected characteristic such as race or national origin or religion. This revision significantly increases the risk that proof of a hate crime would no longer require the state to prove beyond a reasonable doubt that the accused targeted his victim because of a protected characteristic motivation, meaning that the knowledge or perception that the target represented the hated group was the but-for cause of the accused criminal action, but rather that it is enough that the accused engaged in his criminal actions in part because of the target's characteristic. What does that mean? Would anyone charged with disorderly conduct or property damage during a Black Lives Matter protest be subject to hate crimes enhancement because their actions occurred while they were protesting against claims of systemic racism, and therefore the criminal conduct which occurred happened in part because of race? Is graffiti or vandalism of a Christopher Columbus statue expressing opposition to treatment of indigenous peoples targeted in part at individuals of Italian heritage and thus a hate crime? Is it enough that, during the commission of a crime, the accused notices the race, gender, or religion of the victim and makes a negative reference to it? Would a defendant's disparaging posts on Facebook about certain religions or races be admissible to allege that a crime was motivated in part by race or religion? It would seem so. We recognize that the bill, by adding gender identity or expression to the group of protected characteristics and seeking to recognize the community's outrage over hate-motivated crimes, stems from important, laudable goals. But the First Amendment protects the right of the speakers to express vile opinions, and we must remain vigilant to prevent our criminal laws from trying to impose enhanced penalties solely on the basis of such speech or protest activities. Further, broadly worded hate crimes inevitably give prosecutors and the police wide discretion to decide who will face enhanced criminal penalties, and they're just as apt to be used against members of minority communities. One of the first people charged many years ago under Florida's hate crime was an African American who, arrested for assault, called a police officer a white cracker. And when the U.S. Supreme Court generally upheld the constitutionality of penalty enhancements for hate crimes, it was in a case involving not a white supremacist, but a young African American who assaulted a white man after showing of the movie Mississippi Burning. Of course, colorblind enforcement of these laws is appropriate, but it also raises the question as to exactly how helpful they are in addressing the root problem they appear designed to address. The expansion of this law is particularly detrimental from the ACLU's perspective because the hate crime statute is one of only a handful of state laws that contains mandatory minimum sentencing provisions. The ACLU of Rhode Island has long expressed concern that mandatory sentencing takes away needed discretion in the judicial process.
2 more minutes.
That is true no matter what
Lynette,
the crime.
2 more minutes.
Thank you. I'm almost done.
Okay.
Mandatory sentencing laws have contributed to the mass incarceration of large portions of the population, and especially communities of color, reaffirming it as a this law would reaffirm it as a legitimate tool for expansion in this context.
Thank you.
It would also add a hate crime sentencing enhancement to every offense described in Chapter 44 of Title 11 of the General Laws, which contains over 35 separate offenses, including criminal penalties ranging from such things as breaking glass, applying graffiti, littering on Middletown beaches, defacing public statues, stealing fruits and vegetables, or trespassing on posted lands, and carrying fines that now include fines between $5 and $20. Instead, the provision would make those violations capable of the additional enhancement of hate crimes conduct.
Thank you, Lynette. Thank you for your testimony.
Thank you so much. All right, thank you.
Do we have any questions of this witness from any member of the committee? Chairman Court Vasey.
So your organization is opposed to the language as it's currently written?
Yes, actually, we are. It's not that we're opposed to expanding gender identity or expression. We're strong advocates of protecting that category, which is definitely discriminated against. It's the whole concept of the sentence enhancement on this notion of hate crime, which in so many instances carries the extreme likelihood that people will be punished for their hateful speech, which it's not that the ACLU of Rhode Island particularly likes hateful speech, but we have a long history of standing up for the right of people to express themselves as they see fit without censorship from the government, or in this case, enhanced sentences.
Thank you.
Any other questions from any member of the committee? Seeing none, thank you, Lynette, for your testimony. Next,
Thank you.
Next witness is Randall Rose. Hi, Randall, are you with us?
Yes.
Try to keep it brief, please. You have the floor.
Thank you. I also have concerns about this bill. I do oppose it in its current form, and the bill makes it possible to prosecute people for hate crimes even if they have absolutely no hatred or animus towards the victim or anyone else. So under this bill, if a group of people hold a protest at a business which has treated people with disabilities badly, and they are charged with trespassing against the business, the protesters are subject to hate crime enhancements because disability is a protected category. So the bill says that if the property that is affected by the offense was chosen in part because of somebody's perceived disability or actual disability, then there's a hate crime enhancement. So this bill allows the hate crimes sentencing enhancement. It expands it in two problematic ways. First of all, in allowing cases where there's no animus whatsoever involved on the part of the defendant, and that's what my example of protesters about against a business which has badly treated people with a disability. That's what my example shows. And second, it also allows the bill also allows people to be given a hate crime sentence if the person they have a negative view towards is not the person affected by the crime. And as the ACLU pointed out, that means that the bill is no longer penalizing harm done to somebody because you have an animus against their group. It's penalizing harm it's penalizing even quite minor crimes that don't involve an effort to harm a protected group. And it ends up, and so as a result, the bill is treading into the territory of criminalizing speech or expressive actions.
Thank you, Randall.
Those actions, yes. Sorry, I wanted, if I may, Madam Chair,
Yeah,
I
one
just
more
want to
minute.
speak briefly on the. Yes, thank you. On the there's the last section of the bill is about victims' right to address the court. We have good laws on that already, on victims' right to address the court. This bill expands that in a problematic way. It says that you get the right to address a sentencing hearing as a victim, even if you were not harmed by the crime, as long as you were mentioned somewhere in the complaint, indictment, or information. I understand that normally people who are mentioned in an indictment are victims of a crime, but this bill allows them to address the sentencing hearing and make a victim statement, even if the defendant was found innocent on that particular charge, or even if the indictment found a way to mention them, even though they are not the victim.
Thank you, Randall. Thank you for your testimony. Any questions of this witness from members of the committee? Seeing none, that concludes testimony on House Bill 6147. And now we'll go on to Representative Shawcross-Smith's second bill, which is House Bill 6154, an act relating to state affairs and government, Department of Human Services. It requires any facility or business which teaches, gives lessons, classes, or training to children and youth to have their prospective employees submit to a criminal background check through the state or local police department prior to them being hired. Representative Shawcross-Smith, you have the floor.
Thank you, Vice Chair. Once again, I'm honored to present in 6154. And people would say, why would this be a good possible mandate for businesses that teach and give lessons to children to have their prospective employees have criminal background checks? We're all very familiar with the USA Gymnastics situation that happened over the last couple of years. A lot of abuse went on there between owners, coaches, and staff members. So an example of this would be for children, little children, youth, and teenagers, that they take a dance lesson, they take a karate lesson, they go to a lot of camps pop up in the summertime, they go to cooking camp. These instructors would have to have a background check. It would greatly give peace of mind to parents. Also, as a business, I'm also a business owner, the employer would know that they wouldn't have to worry about lawsuits and or the cost of insurance going up. And most important here, it's about the children, keeping children safe. I had a conversation with the Attorney General's office today, and they suggested that this would be the intent. It would be a state background check. It's not a comprehensive fingerprint check. It will be a state background. The intent will be a state background check, which goes about $5. Thank you very much for this opportunity.
Thank you, Representative. Any questions for the representative on this matter, the sponsor? Yes, Chairman Court Vasey.
Thank you, First Vice Chairman McAtee. This is a great bill. I love it. I like it. But I could have sworn we've passed something similar to it in the past.
We've passed many of them, different ones.
and
One
we've
was
never
for
passed this?
volunteers with family services and DCYF, and I don't think we passed an extensive one like this that hits almost everything.
I think this is a great bill. I can't imagine any reasonable person or organization in opposition to this. Thank you.
I have
Thank
to
you very
agree.
much.
I think it's a good bill. Any other questions of the sponsor? Seeing none, we'll go to our first witness, which is Hannah Stern. Hello, Hannah. Are you with us? Oop. Whoa. Not a good sound. A little technical difficulty. Hello, Hannah. Are you there?
Can you hear me?
Yes, I can. Welcome to House Judiciary. You have the floor. Please keep it brief.
I will. Thank you, Madam Chair and members of the committee for your time this evening. My name is Hannah Stern, testifying on behalf of the ACLU of Rhode Island in opposition to this bill. Aside from the fact that there are already just really expansive criminal record check requirements for youth-related occupations already codified in state law, this bill is really just too vague and broad-based. Not only would every single employee be subjected to a check, even if they don't actually interact with youth directly, there are really no meaningful specifications or limits on what entities would actually be subject to this bill, and we just think implementation would be really confusing and burdensome for these reasons. It's also important to note that this bill does not contain a reference to the Fair Chance licensing law, which passed just last session, which ensures that no one is inappropriately denied licensure because of their criminal record. And what this bill actually undermines is this law in some respects. So, for example, an employer would effectively be given the ability to deny someone a job for any criminal record under this language, which is contrary to fair chance licensing and also just extremely concerning for those seeking jobs who may be just as involved but eminently qualified for the position that they're looking for. So we urge rejection of this legislation for these reasons. Thank you very much for your time. I'd be happy to take any questions.
Thank you, Hannah. I would say that I think the premise of the bill is to get to all employees who have access to children, which could mean just about anybody who's around the building where children are taking lessons or classes. So I think it's a good bill. Anyway, any questions from any members of the committee? Seeing none, thank you, Hannah, for your testimony. And that concludes testimony on House Bill 6154. And now to the final bill by Representative Shawcross Smith. And it's a 6172, an act relating to human services, certification of child care and youth servicing workers and operators. It waives the cost of criminal background checks for employees of child daycare, daycare centers, family daycare homes, group family daycare homes, child placing agencies, and residential child care facilities that must be state licensed by DCYF. Representative Shawcross Smith, you have the floor.
Thank you, Chairwoman. This bill, once again, I'm very honored to be presenting 6172. It's kind of a cleanup bill. I just want to give a sense of it. This act would cost the criminal background checks. About 30 some years ago, the background checks were put in for all those categories of people. And it's kind of changed throughout the years. Today, it's a kind of a variety of situations, depending upon what police department you go to. Some charge, some don't charge, some can do it, some can't do it. The state police does it. And then about 3 years ago, now the Attorney General's office does it. And they do definitely charge $40 for the background check. So this would kind of give across the board, go back to where it was 30 years, that there was no cost for this check for any of the providers. It would also save time for the provider shopping around because they might call up a police station, find out they charge $20, hang up the phone, and find out down the street they don't charge, and then they might have a couple of appointments they haven't changed, which I'm hearing is happening across the board. So this bill would actually kind of tidy up things And also would be very efficient, with a mandate for people to follow the BCI checks. It'd be clear across the board, the state of Rhode Island.
Thank you, Representative. Any questions for the sponsor? Seeing none, we'll go to our first witness, Emmanuelfaulk. Hello, Emmanuel. Are you with us? Emmanuel?
Hello, can you hear me?
Yes.
Yeah.
Yes, how are you?
Good. How are you?
Good. Welcome to
on?
House Judiciary.
All right. Thank you, Chairwoman, members of the committee. Oh, sorry. Go ahead, Chairwoman.
Yeah, well, you have the floor, so proceed.
Oh, all right. Sorry. I'll get right to it. Thank you, Chairwoman, members of the committee. This is Emmanuelfaulk with District 1199 SCIU. We represent about 400 family child care providers that are in the CCAP program, and they are vital to providing child care that keeps the economy going, especially for low-wage families in the CCAP program, so that those families can go to work. And they've been underpaid historically, and during the pandemic, a lot of costs have gone up, especially for food and things like that. The rate that they receive from the state covers food, so a lot of costs have gone up, and we appreciate Representative Shawcross-Smith putting this legislation in. Any bit of relief on things like costs for fingerprinting for background checks for providers would be helpful. So we urge the committee's support and thank the representative again for putting the legislation in. Thank you.
Thank you, Emmanuel. Any questions from members of the committee for this witness? Seeing none, thank you for your testimony. Good hearing from you.
Have a good night. Take care. Bye.
You too. Next witness is Tracy Martin Trojan. Hello, Tracy.
Yeah.
Oh, welcome to House Judiciary. You have the floor.
Thank you so much. Hi, my name is Tracy Martin Trojan. I have currently worked in the early childhood field for about 33 years, and I currently work for Cadence Education as a regional director. Last June, Governor Raimondo put the executive order in to reopen Rhode Island. And during that time, our staff started coming back, but due to COVID, we didn't get a lot of staff back. We had to rehire about 29 to 30 staff, and I still need to hire roughly around 20% more to our workforce. Our business is still down between 35 and 40%. Fingerprinting is part of the onboarding process in child care, and for the most part, it was no cost to early childhood educators through the city, the town police. However, there's no consistency throughout Rhode Island. So some police departments charge, some do not charge. So about 3 or 4 years ago, it was put in place that educators go to the Attorney General's office. However, the Attorney General's office also charges $40, which is the cost to the employer or the employee. Some of the staff have to take transit to get there because they don't have cars, and that's an additional cost. Child care is part of our economy. It's a safe, nurturing, educational place for parents where they have a peace of mind and they can drop off their child there. So we need these employees at our place. I'm proposing that fingerprinting throughout Rhode Island be consistent through the police departments, the towns, and the Attorney General's office at no cost to employees so they can also have a peace of mind when they go to work. That's about all I have right now. I'd like to thank you for this opportunity and your time today.
Hello.
Hey, Rick, can you hear us?
I can, Mr. Chairman. How are you?
Sorry. Why didn't you just tell me that? Okay, Rick, welcome to House Judiciary. You have the floor.
Thank you very much, and I'll take very little time because I know you've heard from better experts than me, but I represent, this is Rick McAuliffe, and I represent all the YMCAs in the state of Rhode Island. I also represent the business owners of childcare, and I represent the Rhode Island Child Care Directors Association. So I represent basically the child care industry here in Rhode Island, and proud to do it, specifically center-based facilities. I want to stand in strong support of Representative Marianne Shawcross's bill. I don't think anyone knows the industry more than Marianne Shawcross Smith, so I think this is a good piece of legislation. And here's why. Right now, we see a lot of turnover in this industry, unfortunately. And I know you and your colleagues are addressing the funding issue. I know the Finance Committee is doing it as well. But one of the issues is to get people up and running and working, and we support 100% background checks. We want to make sure that the people that are working in this industry have the proper credentials and also the proper background to do this. The issue we have, unfortunately, is that when you go to your local, as it was said before, if you go to your local municipal police department or you go to the state police, they do it for you. But because of their short staffing, especially at the municipal level, it may take a little while, but it is free. When you go to the Attorney General's office, and credit to them, they are very quick and they do a very thorough background. They do charge $40. And, I think this is while it's not a large cost, when you're dealing with small margins, it does get up there. You have a lot of child care centers that hire 35 to 50 to 65, 70 people a year. And, they all pay for it. And most of the time, the employee will pay for their background check, and they get reimbursed once they get hired. I went online as I was waiting for this committee. I serve on a number of boards, and I coach my children's basketball, softball, baseball, and football. And all through the years, when I've gotten a background check, it's cost me $5, in some instances $10, but certainly not the amount of money that's being charged over there. And I'm sensitive to overhead and the paperwork that needs to be done at the Attorney General's office. But I think this is important for our industry. I think it's a good piece of legislation. I can tell you all the YMCAs, all the child care owners and directors in the state that are center-based strongly support this legislation, and I'd urge the committee to seriously think about this. If they want to help small businesses and make them thrive and want to make sure that our child care centers and early childhood education is good economic development, we need to make sure they have the tools. And I think this is a small but significant step in the right direction, and I implore or ask the committee to seriously think about this as you deliberate your bills this session.
Thank you, Rick. Thank you for your testimony. Any questions of this witness? Seeing none, that will go to our next witness, which is Hannah Stern. Hello, Hannah. Are you with us?
I am.
Welcome to House Judiciary again, and now we're on Bill 6172. You have the floor.
Great, thank you. Thank you, Madam Chair and members of the committee for your time this evening again. My name is Hannah Stern, testifying on behalf of the ACLU of Rhode Island in strong support of this legislation. State law has long provided that no one can be required to pay to file an employment application, but from our perspective, this statute is often undermined by other statutory requirements which make individuals pay for their own record checks. If the state feels that a criminal record check is essential to being hired for a job, we believe that the state should also be responsible for paying for that and not put the onus on the applying individual who really could have a financial barrier put in front of them through this requirement while they're trying to access employment. So we think that this bill appropriately recognizes this, and we strongly urge passage. Thank you for your time. Happy to take any questions.
Thank you, Hannah. Any questions of Hannah Stern from the members of the committee? Seeing none, thank you, Hannah. And that concludes the testimony on House Bill 6172 and all the testimony on Representative Shawcross Smith's bills. Thank you for joining us tonight, Representative. And next we have Representative Knight's Bill 5084. Representative Knight.
Thank you, Madam Vice Chair. This is Bill 5084 by myself. It is a bill relating to expungement, and it allows for the sealing of records pertaining to cases for which a person is acquitted or otherwise exonerated from a charged offense and eliminates the $100 fee for the expungement of the criminal record. We have been over this a few times in lots of different bills because there's 3 or 4 out there that try to get rid of the $100 fee. Legally, what this does is if someone is charged with a case and that case is dismissed, then they can seal the record if it's because they are exonerated. Currently, that's the case unless you have a felony conviction. So let's say you had a possession of cocaine charge when you were 20 years old, and then 30 years down the line, you get, I don't know, you get mistakenly arrested for like shoplifting, and then they let you go. They dismiss the case. You didn't do it. They were mistaken. You cannot get that shoplifting off your record because you have a prior felony offense, even though you're exonerated, which has always struck me as just awful and wrong. And that $100 fee to expunge a criminal record is also awful and wrong. It's yet another roadblock in when we tell people, look, pay your debt to society, and then you can get on with your life with a clean slate. We put a hurdle in front of them. It may seem like a small thing, but for many people it's not. It's $100 to get your record expunged, and that's awful. So this bill would get rid of both. We have 2 witnesses on this matter. Can we have the first one, please? Assuming the panel doesn't have any questions. Hello, you're on with...
Yes. Chairman, I have a question.
Sorry, Rep. Lombardi, I missed you. Go ahead.
That's okay. I'm very missable. That's okay. Thank you. So, Representative Knight, I just indicated something. So you're saying if you were charged with cocaine 20 years ago and you're exonerated on a shoplifting 20 years later, you cannot get that record expunged and sealed and destroyed?
That's correct.
Under current law?
Yeah.
I've never had that problem with that particular situation.
If you have a previous felony conviction, you are not technically eligible to seal any kind of dismissal or exoneration. And clever lawyers work up all kinds of ways to try to get around it, but it's there.
Yeah, I've never. So you're saying 20 years. So say you got a 5-year suspended sentence, and 10 years after completion of that sentence, you're eligible for expunging the cocaine charge, and then you're acquitted, or there's no finding on the shoplifting, you can never expunge that?
Yeah, so what you would have to do in that case, so this is expungement math, right? You had an old possession of cocaine charge, you got a suspended sentence. Now let's say you're eligible to expunge, and you have this shoplifting dismissal. You have to expunge the felony case first, and then come around and get rid of the shoplifting. But let's say you're the kind of person who has cocaine charge and, I don't know, a disorderly conduct that you took 6 months suspended when you were 21. Now you're 40, you got the mistaken shoplifting charge. You cannot get rid of it because you can't expunge the prior possession because you're not a first-time offender. And because you're not a first-time offender, the shoplifting exoneration stays on your record, and people ask forever, hey, what was up with the shoplifting charge?
Yeah, I totally agree with that, but I was just going by your first example. I'm going to respectfully disagree with you. I've never had a problem expunging someone's record and getting that shoplifting sealed and destroyed, but I guess maybe I just caught a judge that was feeling good that day, I guess, about what my case was. But okay, thank you. I appreciate that.
Fair enough. Does anyone else have any questions on the bill? Seeing none, can we have the first witness, please? Hello?
Hello?
Nothing worse than dead air. Ryan, are you there?
Hello. I'm here. Can you hear me?
I can. We're having some issues tonight. Ryan, you're here with the House Judiciary Committee on Bill 5084. Go ahead.
Well, thank you, Mr. Chairman. Ladies and gentlemen, once again, this is Ryan Holt, the Director of Legislative Affairs for Attorney General Nerona, speaking in support of House Bill 5084 that you, Mr. Chairman, Representative Knight, have introduced on behalf of the AG. I was able to hear a little bit of your description of this bill, which was, as always, well done. The bill is, we think is a relatively simple fix that could actually really help a lot of people. One, by waiving or by striking the $100 expungement fee from statute, but also by expanding eligibility for the motion to seal. And I was able to hear a little bit of your description about that, Representative. But I wanted to just kind of give a little bit of background on some of, why we are proposing this change. And as many of you know, criminal justice reform is a main issue that the Attorney General is passionate about, particularly issues around expungement and helping people exercise their rights under Rhode Island's expungement statute. Prior to COVID, the office hosted several expungement open houses throughout the state, which attracted hundreds of people. And we hope to do so again once it's safe to do that. Although, as the COVID crisis went on, we moved this process online. But basically, what we did is, and the attorneys on this panel will know that while we have a pretty good expungement law on the books right now, sometimes it's a bit difficult to navigate to determine whether or not you are eligible. So we helped people through that process. Basically determined whether or not they'd be eligible, and so far over 600 folks have done that with us, either in person or online. But obviously, it's a great way for us to talk to people and to hear what folks are going through. And in some of those conversations that we've had, either myself, the AG, other members of our team have had, is that $100 fee. As you said, Representative Knight, does present a major impediment for folks, and it just really shouldn't be there. It's an unnecessary barrier to somebody exercising their rights, because as we all know, having a record that is clean, if you deserve to have that clean record, just can go such a long way in reducing recidivism and really helping folks move on with their lives after they paid their debt to society. And also, I won't once again go into the extension of motion to seal, just saying that it's really a common sense thing. I mean, if you are charged and the crime is dismissed, you should be eligible to have that sealed. And if there are any questions, I'm happy to take them.
Does anyone have any questions for Mr. Holt? Now this time, I see Rep. Lombardi on the screen. Go ahead.
Thank you, Rep. Sorry, my hand is bigger than the world sometimes, but so let me ask this here. Would it be maybe appropriate to allow the judges to have discretion and to have, hear reasons why the $100 fee can be waived? And, COVID would be an issue, not being employed would be another issue. Because I had a felony record, I was never able to, exceed my potential and so on and so forth. Is that another way of getting around this?
So rather than striking it entirely, Representative, is that your question?
Yes.
I mean, we certainly could do that, but I think, you as the General Assembly could write something in to give the judge's discretion. I do know that, some folks do ask for a waiver when before the judge, but I think a smarter solution, and one that's easier for everybody involved, and just kind of more friendly to folks trying to exercise their right, is just striking it entirely. I will tell you, I've had conversations with the courts about this issue. They have not indicated concern about striking this fee. And I don't think it would present a major fiscal impact to the state as well. I mean, you're not talking big dollars here.
Yeah. Listen, I'm in total support of striking it. I think, I've always said expungements, and I get questions about that a few times a week from people, you know. But,
sure.
Yeah, so I have no problem waiving that $100 fee, striking it. I don't have a problem with that at all. Let me ask another question, if I may.
Sure.
The fact that the Attorney General was able to effectuate 600 or so expungements, do you think maybe that there are many more people out there that would be willing to do it, but because it was the Attorney General's office, and this is just a question I'm asking you to hypothesize, because it was the Attorney General's office, the office that prosecuted them potentially, that there are maybe 6,000 more out there, and you know, is that something that's possible?
Well, there are certainly, you know, I would imagine there's lots of folks out there. It's just getting the word out, and I would also just note that, you know, some of these were offenses that were prosecuted by city and town solicitors as well, if they were misdemeanor offenses. But I get your point, right? Because you know some people see AG as law enforcement, they might not want to do that outreach, right? I do know, and I know that there are other organizations in the community that are active in this. I know the public defender does some work on this issue. And look, the more people that want to do this work, the more people that want to get the word out about this, the better. This is a good thing. It's a way to let people know what their rights are. So yeah, I mean, look, there's no one major solution that fixes every problem. We're just one avenue for it.
Yeah, it's not meant in a derogatory way or.
Oh no, not at all.
I just want to let you know. I can tell you from my perspective, if you guys prosecuted me, I wouldn't be coming to you to clean my record. I'm going to be totally honest with you, but that's just another story for another day, maybe. So thank you, sir. I really appreciate it. Thank you.
Absolutely, Representative. Thank you.
Does anyone else have any questions for Mr. Holt? Seeing none, Ryan, thank you for your time tonight. Can we have the next witness, please? Hello, Hannah?
Yes.
Hi, you're on with the House Judiciary Committee on Bill 5084. Go ahead.
Great. Thank you. Thank you, Chairman and members of the committee, for your time again this evening. My name is Hannah Stern, testifying on behalf of the ACLU of Rhode Island. In strong support of this bill, I'll be very brief. There have been a few bills heard by this committee recently which would accomplish the goal of this bill, and we've supported all of them and support this legislation for those same reasons. This would just importantly remove what could be a sizable financial barrier for individuals who qualify for expungement, and we urge passage of legislation of this nature. So thank you for your time. I'd be happy to take any questions.
Does anyone have any questions for Hannah? Seeing none, Hannah, I appreciate... Oh, sorry, I missed you. The screen over there keeps shifting. Go ahead, Rep.
Is that for me, Rep. Knight?
Yes.
Okay, sorry, trying to get your attention. I know you're a busy man, but see, the problem is I'm busy. Anyway, for Hannah, again, I totally agree with everything you said. Hannah, is your reading of 12-112, and this lawyer talk, and I'm sorry I'm doing this, which is when a matter is dismissed or not guilty. My reading of that is that some of this stuff should be done automatically. Would that be a better way to effectuate this, where, once you're acquitted, that it's automatically expunged, sealed and destroyed from your record?
Yeah, I mean, the ACLU is generally in favor of measures which would provide for automatic expungement. So if I understand your question correctly, I think that the answer would be yes, that automatic expungement would always be a great and really efficient tool for instances like this if someone is qualified.
Okay, thank you, Hannah. I just think that statute does say that, but that's my reading of it. I have a very broad and liberal reading of that statute. So thank you. I appreciate that you support that, but I do support everything you said. Thank you.
Thanks.
Anyone else? Anyone on the video? All right. I'm off my game tonight. Thank you, Hannah, for your testimony. We certainly appreciate it. And that concludes testimony on Bill 5084. Mr. Chairman, back to you.
Thank you. The next to the last bill, before we get to the remainder of Representative Noray's bill, is mine. It's an act related to criminal offenses, sexual assault, and specifically it eliminates the marital sexual assault exception when a victim is incapacitated, disabled, or helpless. And we have Peg Langhamer from Day One, who is an expert in this field of sexual assault and the victims associated with it. Can we get Peg on the line? Hi, Peg. Bob Craven. You are on the air.
Terrific.
Ready to roll.
Thank you, Chairman. Thank you, Chairman Craven. My name is Peg Langhamer, and I'm the Executive Director of, let me turn this down, of Day One, which is the statewide organization primarily focused on dealing with issues of sexual abuse. I want to thank you, Chairman Craven, for introducing this bill and supporting it. This will essentially eliminate the marital sexual assault exemption, which has been on the books for way too many years. Believe it or not, up until the mid-'80s, it was still legal to sexually assault one spouse, not only in Rhode Island but throughout the country. And Rhode Island was really one of the first states to get rid of that exemption and eliminate it all except for when a victim is incapacitated, disabled, or helpless. And there was a rationale for that in those days. People were concerned about, basically that anyone who had developmental disabilities could not engage in consensual sex. And what we've seen over the years, there's no need for this language. We need a clean first-degree sexual assault statute. We are one of the last states to really clean this up. We think there are only about 11 states left that have this kind of an exemption, and so we strongly support this. We know there is no time when sexual assault should be accepted and legal, and a marriage to another human being is not a license to rape. And so we're about to pass this last year before COVID, and as Chairman Craven also supported it, introduced it at the time. So we're a little bit behind, but hopefully we'll be able to pass it this year, and we strongly urge support of this bill.
Thank you, Peg. Is there any questions from the members of the committee? Okay, Peg, thank you. That concludes testimony on House Bill
Thank you.
6155, which brings us to the last bill that we began with Representative Noray. And we are going to the 48 remaining witnesses that are on the telephone. For those of you that are expecting a call from us, I ask that you turn your volume down when you receive the call on your computer, and each of you will have 1 minute and 15 seconds. At the conclusion of that period of time, we'll terminate the phone call and move on to the next witness. That'll allow us to finish in a timely manner tonight. So the first witness is Amity Gardner. Amity, you're on the air.
Hello. Thank you for allowing me to testify. My name is Amity Gardner from Southern Rhode Island, and I'm calling in to testify in strong favor of Bill 5989. And I just want to make a few points. Number one, that just like the flu vaccine and things ever changing with viruses, we don't actually know that anything will develop into a herd immunity probability with this vaccine. And with previous statements from the panel, I heard a lot of comment on that. So just wanted to remind everybody that we're not at a point where we even know that. But also, there's been comments about children and the schools, and that kind of a circumstance should allow for a mandate, and adults should have a choice too. Adults are parents that have children to make the choices for them, and the adults should still be able to choose on behalf of themselves and their children without a form of coercion. And coercion is things like keeping your job, attending school, and such. And medical decisions should not be discriminated against any more than your race or your ethnicity, as it is equal of importance, because when you file citizens into a group or category and take action against them, that is by definition discrimination.
Thank you, Amity. Your time is up. The next witness is Liam Gardner. Joe Daly. Joe, you're on the air. You got 1 minute and 15 seconds.
Good evening. Thank you. My name is Joe Daly. I'm from South Kingstown, and I'm here to support this bill. I'd really like to thank Representative Norrie and the co-sponsors of this bill, and all the lawmakers there who will listen tonight with an open mind. We're truly honored to have legislators who are willing to stand up for the most vulnerable communities in the state. And you may wonder which community I speak of. I speak for the children, the parents, the families, and the individuals for whom vaccine injury is their reality. For my friend's brother-in-law, a healthy adult who got Guillain-Barré syndrome from the flu vaccine is now paralyzed. For the son and daughter of dear family friends who suffered permanent neurological disability from vaccine injury. For my own children who have a genetic mutation that puts them at risk. It's not a privilege to worry that vaccination may result in serious injury to our children or our family members. We didn't choose this genetic mutation for our family. We were born with it. The privilege of vaccination is for those people who can receive them without any adverse event. In October of 2020, the Wall Street Journal printed an article stating that over $4.4 billion have been paid out over the last 30 years for vaccine injury, ranging from the flu vaccine to polio and more. The reality is that although many of us don't talk about it, we may not know someone, there is a small subset for whom grievous injury from vaccines is real, and yet there is no screening done. Unfortunately, the particular allergy, immune condition, genetic predisposition, or other medical factor that leads to a result of a injury from a vaccine is only made after it's too late. Why do people have to suffer a life-changing injury before they're made aware of the risk or qualify for medical exemption?
Joe, your time's up.
To wrap up, I would just like to say that vaccine mandates for employment put Rhode Islanders in the untenable position of having to choose between their livelihood and their health. And I don't think that's a position that any working Rhode Islander should have to be forced into. Thank you. I appreciate the time.
The next witness is Carissa Magoli? No answer? Ellen Schaefer? Ellen, you're on the air with the House Judiciary Committee. You have 1 minute and 15 seconds.
Thank you, Chairman Craven, and the many committee members who sponsored H5989, and to all committee members for your service to Rhode Island. I'm testifying in support of this bill, and I strongly urge each of you to pass this through to the House floor for a yes vote, as the Rhode Island resident, parent, small business owner, and an individual who has in the past been both an employee and in a position to interview and influence hiring of other employees, it's unimaginable to me to suggest that a candidate or current employee would need to involuntarily submit themselves to an injected medical intervention that is inherently risky, is without liability, and is not even approved by the FDA in order to secure employment, credit, or to shop as any member of society is welcome to do. With respect to considering it a privilege to make a choice to not be vaccinated, I echo, that people who have witnessed injury or death in their family are not feeling privileged when they're trying to avoid further injury or death for either themselves or their children. This bill, I believe, is the exact opposite. I believe that it is inclusive of all people in recognition of all of our bodily autonomy to decide what human-made, inherently risky products do or do not penetrate us or penetrate our children. Therefore, I respectfully urge you to vote this, pass this through to the House for a yes vote on the floor. Thank you so much.
Thank you, Ellen. Next witness is Aaron Dusso. Aaron? Aaron?
Yes, hi.
You're on the air. You've got 1 minute and 15 seconds.
Thank you. My name is Erin Dusso, and I'm a resident of Burnsville, Rhode Island, speaking in support of this bill. I'm a mother, human resources professional, and chapter leader for Freedom Keepers United, Rhode Island. As an HR professional working in a global company, I've seen vaccination discussions open up opportunities for other forms of discrimination against already protected classes such as religion and disability status. I've had private conversations with many employees who feel uncomfortable in the workplace due to the rampant conversations around vaccines for COVID-19. Their fears of being denied opportunities because of their beliefs are real and valid. Medical freedom is a basic human right. Rhode Islanders should be able to choose where there's a risk without fear of losing their livelihood or their children not being afforded the same benefits of a public education. Each individual has the right to make medical decisions that are best for themselves and their families, especially when no vaccine has been evaluated for carcinogenic or mutagenic potential or impairments or fertility. I am confident that Rhode Island can stand up and lead by setting a precedent that says we value all of our citizens equally. I believe regardless of vaccination status, our state can remain a safe place to raise our families. Thank you for your time and consideration.
Thank you very much. The next witness is Rick Provost. Rick, you're on the air. You've got 1 minute and 15 seconds to give your testimony.
Okay, thank you. Honorable Chairman Craven, honorable members of the House of Representatives Judiciary Committee, any language in a law that requires mandating vaccines would create a dangerous social situation, a categorization of human beings as safe versus unsafe, deserving versus undeserving, based on their own individual rights, regardless of their medical freedom. Regarding their medical freedom. I passionately and intentionally support any and all language that would prohibit discrimination based on an individual's vaccination status. Necessitating that an individual divulge their vaccination status at threat of losing employment, accommodations, or access to fundamental goods and services is a violation of our Fourth Amendment right to be secure in our persons and personal effects against unreasonable search. In many cases of those refusing vaccines, that information would reveal religious beliefs and medical issues which prohibit them from being vaccinated, exposing them to further discrimination on those grounds and violating their First Amendment and 14th Amendment rights as well. I thank you for your fullest consideration and support of our medical and religious freedom and the right to choose what benefits our health. Thank you.
Thank you very much. The next witness is Cherie Wallach. Cherie, you're on the air. You've got 1 minute and 15 seconds.
Okay, hello, I'm Sherry. I'm from Portsmouth, and I just wanted to call in support of this bill. I'm really pleased to see a bill like this being introduced right now in Rhode Island. It is so important because health, wellness, protection, it doesn't come as one-size-fits-all solution. For some of us, injecting vaccines with the toxins actually doesn't promote health in our minds. It actually includes inflammation, disease, autoimmune. These vaccines for COVID have been fast-tracked under warp speed, and we don't know the long-term implications, especially in fertility in our children. And we're talking in this board about giving it to children and mandating it. That's very scary for parents and adults who have actually seen vaccine injury. So I urge you for this bill for anti-discrimination, because we have a voice. We are people, we are humans, and we all matter. Thank you.
Thank you for your testimony, Sherry. Next witness is Alyssa Reese. Okay. Madalena, you're on the air. You've got 1 minute and 15 seconds.
Hi, good evening. There are many reasons why a person may wish to decline a new, experimental, preemptively indemnified vaccine that has not been evaluated for its effect on viral transmission, only symptoms. I have a genetic mutation that impairs my ability to process toxins. This isn't my choice, and I have a long history of overreacting to pharmaceuticals such as anesthesia, pain medications, even antibiotics. I am at higher risk of an adverse reaction, yet I don't qualify for a medical exemption. In order to get a medical exemption, you have to show evidence of prior injury, and then the exemption is only to the specific vaccine that injured you, not for any other vaccine. I am very afraid of having to choose between my health and my job. I support a family of 5. If I were to lose my livelihood because of a COVID vaccine mandate from my employer, how would I pay my mortgage? Who would feed my kids? Informed consent cannot be given under such extreme duress as employment mandates. How can we be forced to take an experimental, liability-free product in order to support ourselves and our families? Rhode Islanders have lost so many things this year. Please ensure that the right to work isn't one of them. Anti-Discrimination Bill 5989 protects the right to work. It protects the right to say no, and it preserves bodily integrity and informed consent. Please, I urge you to pass this bill out of committee, and thank you so much, Representative Nuray, and the many committee members who sponsored this wonderful bill. Thank you for your bravery and your advocacy.
Thank you, Madalena. The next witness is Joseph Reese. Joe, you're on the air. You got 1 minute and 15 seconds.
Okay, it's my opinion that people should have their own right to be vaccinated or not. They shouldn't be told that they have to be vaccinated. That's my opinion. It's a free country, and I think people have the right to make their own choice whether to be vaccinated or not be vaccinated. Thank you.
Thank you, Joe.
Thanks.
Next witness is Eleanor Carnavalo. No answer. Next witness is Thomas Glazer. John Soers. Emilio Zioli. Emilio? Emilio? Kelly Moran? Should be filling this with commercials.
It's an exciting show.
Yes. I've memorized a few from my childhood, so I could...
You said you could sing.
I do. I can sing.
Let's hear a few bars.
I usually only give those in bars. Kelly? No luck with Christine Waldeck? No? Christine, welcome to the House Committee on Judiciary. You've got 1 minute and 15 seconds to give your testimony.
Good evening, Chairman Craven and members of the Judiciary Committee. My name is Christine Healy-Waldeck. I am a Rhode Island parent and co-founder of the Rhode Island Wellness Society. I stand in very strong support of House Bill 5989. Thank you so much, Representative Norrie, and all of the co-sponsors for this legislation. I appreciate you so much. I am deeply concerned that vaccine mandates for employment and public accommodation will unfairly, harshly, and negatively impact many vulnerable Rhode Islanders and our fellow Rhode Islanders with disabilities and those with underlying medical conditions. It clearly states on the FDA emergency use authorization fact sheets and the FDA briefing documents for the new COVID-19 vaccines that people who are immunocompromised, which includes people with autoimmune conditions, may be contraindicated. I am gravely concerned that there is no consistent, widespread medical pre-screening or testing of vaccine recipients for allergies or genetic predispositions, where a procedure of vaccination could trigger autoimmunity or debilitating anaphylactic reactions. Because the PrEP Act and the 1986 National Childhood Vaccine Injury Act shields all pharmaceutical companies, vaccine providers, and employers from liability for harms and deaths that the medical procedure of vaccination can cause. We need protection for those who decline and protect people's right to earn a living and feed their families. Since all of these COVID-19 vaccines are still not fully approved by the FDA and are under emergency use authorization status, I fear when vaccines finally do become fully licensed and approved by the FDA, more businesses and employers will be more inclined to make it mandatory for their workers. For people with disabilities like my daughter, who already suffered debilitating adverse reactions from vaccination, this will be very problematic for her when she tries to find meaningful employment or volunteer work. Although she has an exemption, she and people like her still may be targeted and unfairly discriminated against, all because of their medical condition and vaccination status.
Christine?
The United States
Christine, you got 15 seconds left.
Oh, in closing, this anti-discrimination bill would not in any way restrict a person's access or choice to the medical procedure. However, 5989 will empower all Rhode Islanders to make appropriate decisions for themselves and their loved ones. Please help protect diversity, our human rights, the human rights of our children, and the human rights of all Rhode Islanders. Thank you so much for your time and consideration.
Thank you, Christine. The next witness is Mary Kelly Sutton, MD. Dr. Sutton?
Yes.
You are on the air. You've got 1 minute and 15 seconds.
Thank you very much. Please support H5989 for the following 4 reasons. Number 1, keep personal medical information private. Vaccination status is comparable to HIV status and any other diagnosis and can easily be kept confidential and still achieve the goals at hand. Number 2, accurately identify who is a public health risk in the time of emergency through symptoms such as a questionnaire and a temperature check. Being vaccinated does not mean being healthy. Assuming it does will misguide the necessary response. Each vaccine has a different effectiveness profile. We assume vaccines all do the same thing, create no symptoms and no transmission, but this is not accurate. Vaccination status is not a guarantee that a person does not have that disease. Number 3, avoid the unnecessary damage to those who are vulnerable to vaccine side effects. For example, in COVID, 20% of the population has had the disease, and it is those who are at highest risk for the serious adverse reactions if they are vaccinated now. Number 4, use all public health options, not just vaccination. We do this routinely when we dispense iodine for nuclear disaster, when the WHO gives high-dose vitamin A for a few days around a measles outbreak, and countries around the world have provided early treatment for COVID-19 with zinc and hydroxychloroquine with very excellent benefit. Dr. Peter McCullough, MD, has reviewed the 4 pillars of pandemic treatment: behaviors such as masks, social distancing, early treatment, hospitalization, and vaccination. And he points out that the U.S. has totally skipped early treatment to the detriment of the public. Rhode Island can learn from this omission. Thank you for considering all sides. The goal is to newly understand the balance of risks, collect accurate, meaningful information, and use a broad range of public health options. Please support H5989.
Thank you, Dr. Sutton.
Thank you.
Next witness is Becky Breslin. Becky, you're on the air with the House Judiciary Committee. You have 1 minute and 15 seconds.
Great, thank you, appreciate it. Hello, my name is Becky Breslin from Portsmouth. Thank you for the opportunity to speak today, and special thanks to the sponsors of this bill. I'm calling in strong support of this anti-discrimination bill 5989 where vaccines are concerned. My feelings are this: if there is potential risk, I feel we must provide choice. How can we mandate anything with death as a possible side effect? There were many references earlier to taking the COVID vaccine for the greater good, but the vaccine has been proven to minimize our own symptoms only. The CDC, Fauci, the WHO, Pfizer, and Moderna execs have all said that this vaccine has been proven to stop the spread, have all said that this vaccine has not been proven to stop the spread of the virus, Among other things, that is why they are still recommending masks after you get the shot. If you want to mitigate your own symptoms and are willing to take the associated risks, you should get this vaccine. But it's important that we not misinterpret that taking this vaccine constitutes impacting the greater good. While the mainstream media doesn't love to amplify this message, it is true. I respectfully encourage you all to go research these facts if you aren't already aware of them. It's all there for us to see and read. If government wants to mandate these vaccines, then we must overturn the 1986 law providing indemnification for these pharmaceutical companies. That may go a long way in restoring people's confidence in these vaccines, and I can only hope it will also minimize the number of adverse events. But to fire a person or discriminate hiring a person because their choice to forego a vaccine that could injure them feels like coercion, feels anti-American, and is a violation of basic human rights. Thank you.
Thank you, Becky. Next witness is Laura Stella Eidenstein. Oh. Okay. Tara, you're on the air. You have 1 minute and 15 seconds to testify.
Okay. Hi, my name is Tara Lavassa. For Bill 5989, vaccine mandates is a violation on human civil rights. The statement, "My body, my choice," rings louder today than it ever has. Forcing a person to take the COVID vaccine for a job is serious intrusion in the individual liberty and autonomy. Americans should have the freedom to take a vaccine as well as they should have the freedom to decline a vaccine. Americans have the right to be fully informed about vaccines, unknown potential long-term effects on cancer, birth defects, or interactions with autoimmune diseases and responses. However, the COVID-19 vaccine is still in experimental phase and has only been released by the FDA as an emergency use, not being fully approved until 2023. At this point in time, it is still not clear on how now that the vaccine is to prevent transmission or migrating symptoms. Therefore, how can a government or employer mandate vaccines that will lead to bad consequences that will affect millions? Nevertheless, if we allow our government and employers to dictate what we must inject in our bodies, what are the limits can be placed on its own power, and where do we draw the line? Thank you for your time.
Thank you very much. Next witness is Kim. Okay. Rebecca.
Yes.
Hi, it's Bob Craven.
Hi, Bob.
Good, how you doing?
Good. Thanks for the call, Bob. I'm one of your constituents, and I want to thank you for taking the time tonight, and everybody else who's giving their time to hear this. Am I ready?
Yeah, 1 minute and 15 seconds, but go ahead.
Great. All right, great. Thank you to all that have supported this bill. I'm speaking in strong support of 5989. Every Rhode Islander should have the right to deny the vaccine based on their personal, medical, or religious decision and should not be discriminated against. I run a small business in Rhode Island for the past 20 years and need to rent indoor sports facilities to run my business. What if I am denied renting the facility unless I have been vaccinated? How am I going to support my family? This coerced consent is exactly why I'm supporting this bill. This also would impact my athletes that may be denied access to a building if they're not vaccinated. I know many individuals that have opted out of certain vaccines due to adverse reactions or have had spread out the CDC recommendation schedule of vaccines. Especially with this vaccine not yet being FDA approved, people should have the right to choose what to put in their bodies and not be discriminated against based on their decision. As a parent, my right should be honored as to being required to inject my children with the vaccine that is still on trial period. We do not know the long-term effects of this vaccine and will have on our children, and we should not be discriminated against for making an informed decision that we believe is best for our children. Please support this bill, and we thank you for all your efforts that you do to represent us.
Thank you, Rebecca. Next witness is Bill Flynn. Oh, I'm sorry. We've got a question for you, Rebecca. All right.
Excuse me, Chairman, I just wanted to ask her, and I'll have her maybe email me something, about the sports team she was talking about for college athletes. I wanted to know how...
I've got her telephone number right here.
I'll get it from you, and I'll reach out to her and have her email me. I'd like to expound on that. Thank you.
Thanks. Bill Flynn? Billy?
Chairman Craven, members of the committee, thank you very much. This is Bill Flynn from the Senior Agenda Coalition. We are in strong opposition to this legislation. It creates a threat to the health of vulnerable seniors and others receiving care anywhere. Any health care facility that does not require its direct care staff get vaccinated against not only COVID, but it also would apply to any other vaccines against contagious diseases such as measles, mumps, chickenpox, and so forth. It is in direct and clear conflict with Rhode Island general law, and I won't give the citations. They're all in my written testimony and in Department of Health regulations about immunization and testing. I will note that the regulations do have an exception for healthcare workers. There's a medical exception if they can document that through a certified provider. This is an end run around our state's public health policies and Department of Health regs to define vaccination as some form of employment discrimination. They are no such thing. Workers have a right to refuse. Nobody's mandating that people get the vaccine, but it is not an unlimited right applying to all workplaces. It does not apply and should not apply to healthcare facilities. These facilities' state licenses require they must comply with Department of Health regulations on immunization of direct care workers, not to mention their responsibility to protect their patients and staff. As a practical matter, providers like nursing homes not only have a duty to protect the health of their patients, but they have a strong corporate self-interest, and they are working hard at persuading their direct care staff to become vaccinated rather than sanctioning or firing them because, as some of the members have noted, that they have an ongoing challenge in hiring and retaining direct care staff, especially true for nursing homes. Members of the committee, ask yourself this question. Would you want a loved one in a nursing home with staff who haven't been vaccinated? Or would you like to have a loved one receiving home care from a person who wasn't vaccinated or receiving any other kind of service? This is a critical and important issue, and the disinformation and the idea that this should trump established procedure in state law, in my opinion, it makes no sense whatsoever. And I noted that there is plenty of written testimony from the Department of Health about this, and I urge you to read it. Thank you very much.
Thanks, Bill. Any questions of Bill Flynn? Oh, the sponsor has one, Tom Noray.
Mr. Flynn, thank you for your testimony this evening. I absolutely don't disagree with you on many points. And again, if you heard earlier, I realize that this bill definitely needs some additions to it, and I'm absolutely willing to work with you or anyone else to make those amendments to try to make this the best bill we can. Thank you.
Thanks, Bill. Next.
Thank you, Chairman.
Hey, how's your jump shot? Can you still?
It's fading fast.
Fading fast. Yeah, mine too. All right.
Okay. Bye.
See ya. Paul Valletta. Paul, how you doing?
Hi, Chairman. How are you?
Good. You got a minute, 15 seconds, Chief.
I'll be quick. Thank you, Mr. Chairman and members of the committee. Usually, we don't get involved with bills that don't specifically pertain to firefighters, but this one caught our eye because we have 3 state laws that govern infectious disease with firefighters and police officers, where we're covered. If we get an infectious disease under state law, we go on injured on duty. We've had several of our departments tell us the policy is going to change for firefighters that aren't vaccinated, that they won't be covered under IOD. They won't be covered as line of duty. We were actually going to try and see if we could put some kind of language into our infectious disease law that presently is in place that would stop them from doing this. So let me say, I've listened to a lot of the testimony tonight, and both sides, they got great arguments on both sides. And just my organization, the Rhode Island State Association of Firefighters, we encourage all our members to get vaccinated. But those people, those firefighters that may not get vaccinated for a medical reason, a religious reason, whatever their reason is, we don't think they should lose their benefits that they're afforded to them under state law and in collective bargaining agreements, which actually have some presumptive language. So, like I said, good points on both sides, but we don't think we should lose benefits just based on whether you get a vaccination for whatever reason. Like I said, medical, religious, or whatever reason the person has for doing that. And we just wanted to weigh in on this. Like I said, we were going to try and put language in this year that made our language stronger for infectious disease. And when we saw this bill come up, and I didn't speak to the sponsor prior to this bill being put in, when it got put in, we're specifically looking at the language on page 2, line 32, that addresses discrimination against an employee for not getting the vaccine when it deals with the terms, conditions, and privileges of employment. So that's our testimony. I appreciate it, Mr. Chairman and members of the committee.
Thank you, Chief. Next
Thank
witness is Kim Bucket. Kim, you're on the air. 1 minute and 15 seconds, please.
Thank you. Thank you to the many committee members for sponsoring this bill. My name is Kim Bucket, and I'm from Barrington, Rhode Island. We all know discrimination based on race, color, religion, sex, or disability is wrong, and medical discrimination is too. To threaten anyone with the loss of the ability to be employed and earn a living, to feed and shelter their family, as well as access to credit and basic function of our daily lives, such as going to the grocery store, is unacceptable. The yellow star required to be worn by Jewish people in the 1940s gave liberty to be treated with aggression, insult, labeled carriers of disease, spit on, and much worse to anyone who was made to wear one, and that was only 80 years ago. We all know the horrors of that time. We cannot allow that type of heinous discrimination to happen again. We must refuse medical apartheid. The words, "my body, my choice," they echo with this bill. Please approve this anti-discrimination bill and protect the citizens you serve. Thank you for your thoughtful consideration and time.
Thank you, Kim. Next witness is Tara Lavoisier. Kristen, you're on with the House Committee on Judiciary. You have 1 minute and 15 seconds to testify.
I support the bill.
Thank you. Next witness is Carissa Magoli. This is Adriana Bonella?
Correct.
Adriana, you have 1 minute and 15 seconds to testify. Welcome.
Okay. Good evening, members of the House of Judiciary. As a resident of Rhode Island, I ask you to support the House Bill H5989. This bill prohibits discrimination against those who choose not to vaccinate. Where there is a risk, there should be a choice. The freedom to say no, the freedom to my body, my choice, the right to make decisions on my own body. No employee should be discriminating for choosing to opt out of this vaccine. Each individual should outweigh the good, the bad, and then make the decision they feel is best for themselves. Once this decision is made, each individual should have the same right as the other employees. Equal opportunity for all. It is our body, our choice. We respect those whom choose to get the vaccine, and we ask you to respect those whom choose not to. Thank you for your time.
Thank you very much. The next witness is Carol Dukas. Carol Dukas. Carol, you're on the air with the House Judiciary Committee. You have 1 minute and 15 seconds to testify.
Thank you very much. Thank you for hearing my testimony. My name is Carol Dawkins, a parent and small business owner in Westerly. And thank you to the many committee members who sponsored this very important, humane bill. A lot is at stake here, namely lives and livelihoods of your constituents. I do not understand how this bill could not be passed. Per the CDC, the deaths reported after this experimental vaccine have surpassed the total deaths from vaccines in the past decade. This is an experimental drug. Legally, that's what this COVID shot is. It doesn't enjoy FDA status as an approved vaccine. We must remember that we literally are the guinea pigs, the test animals in this vaccine trial, and it has been admitted by the manufacturers that it does not prevent transmission. People having to choose, really being coerced into choosing between losing their job, access to credit, public accommodations, or taking an experimental shot, that would honestly surpass discrimination. It would violate the Nuremberg Code. Under that, no one may be coerced to participate in a medical experiment. I know a Rhode Island resident who contracted Guillain-Barré after receiving a vaccine. It took him a year to be well enough to resume work. He's now medically vulnerable. This bill would protect the medically vulnerable and would keep medical information private as it should be. So though we find ourselves in uncertain times, we do know for certain that any sort of medical discrimination is exclusive and dangerous, especially in the light of these experimental vaccines. Please support this bill. Thank you so much for your time.
Thank you very much. The next witness
Thank you.
is Deborah O'Leary. Deborah?
Yes, thank you, Chairman Craven.
1 minute and 15 seconds, please, Deborah.
Yes, sir. Thank you to the committee and to the sponsor, Mr. Noré, for this bill, for starting the conversation. We really needed to have this. I represent a group of parents who have witnessed firsthand what a vaccine injury can do to their child. They want to be able to vaccinate the children if they feel it is safe, but it is not. They have seen it with their own eyes. And now we do have a religious exemption on the books. However, in 2015, that exemption was threatened by the legislature in the Senate to remove it. So that every year when bills come through, my community holds its collective breath and makes sure that that bill isn't going to show up again. We have parents who are constantly looking for a new pediatrician because their pediatrician has asked them to find someone else. They give them 30 days notice, and this is becoming more and more problematic. This is also about discrimination. These parents have healthy children who are being discriminated against simply because they are not vaccinated. That you all must be brave. This is a difficult subject to bring up. And Representative Norrie, you are the bravest of all. I want you all to be brave, and let's really get serious about this, about conformed consent and about exemptions. And please, please stay the course. Let's keep talking. Thank you.
Thank you, Deborah. The next witness is Alexandria Magi? Alessandra?
Yes.
You're on the air with the House Judiciary Committee. You've got 1 minute and 15 seconds to testify.
Okay. Thank you very much for hearing this bill today.
Yep.
And thank you to the sponsors. I'm very much in support of passing it. I think it's critically important to protect people's right to decide what goes into their bodies. And I think this bill would help to do just that. Healthcare decisions are unique to each person since individuals have unique biology, circumstances, and religious beliefs. Vaccines are a medical procedure that come with risk of injury, and they're all liability-free for the manufacturers. Where there is a risk, there must be a choice. If employers are requiring that their staff undergo a medical procedure in order to be employed at their facility, this means that people are being coerced into a medical procedure that has risks, and they cannot even sue the manufacturer for damages if they are harmed. I also have a big problem with aborted fetal tissues and cell lines that are used for the testing and or manufacturing of certain vaccines. I strongly believe people need to have a choice whether these are injected into their bodies and that of their children. I know a family friend in another state that was already pressured to take the shot in order to keep her job, and I think this is completely unacceptable and morally wrong. If citizens are mandated to inject experimental therapies into their bodies in order to participate in society, this sets a very dangerous precedent for other things that might be mandated in the future. Thank you for listening.
Thank you very much for your testimony. The next
Thank
witness, you're welcome. Your next witness is John Piasek. Deborah Jennings. Deborah?
Yes.
You're on the air in front of the House Judiciary Committee. You have 1 minute and 15 seconds to give your testimony.
Very good. Good evening, Chairman Craven and the members of the committee. My name's Deborah Jennings. I'm a registered nurse. I live in Middletown. I wanted to alert you all that the American frontline doctors have crafted a vaccine bill of rights, which they're hoping that many of the states will adopt. And it's there to protect citizens against unconstitutional and medically irresponsible COVID mandates. And they've integrated aspects of international codes such as the Nuremberg Code and the Helsinki Convention, where nobody can be allowed to be coerced into an experimental procedure. We also guarantee our individual liberties in the Bill of Rights. Our 14th Amendment directs states not to deprive any person of life, liberty, or property without due process of law. As has been said, the COVID vaccine is not FDA approved. It's under emergency use authorization, so it's experimental, investigational at present. It will not be approved, if it ever will be approved, until 2023. Emergency use products are specifically prohibited by Federal Law 21 U.S.C. 360 BBB3. I've left links in the email I sent you. From being mandated, it requires the option to accept or refuse administration of the product. This is one of the things being used in a lawsuit in New Mexico, this particular federal law. The Centers for Disease Control Advisory Committee on Immunization Practices, ACIP, affirmed in August 2020 that under the emergency use authorization, experimental vaccines are not allowed to be mandatory. all persons
Deborah?
must have the right. Yes.
Deborah, your time's up.
All right. Well, that's it. We just need the right to make our own decisions and make our own medical choices. And thank you very much for your time. I hope it gets to the House floor.
Thank you. Next witness is Kelly Baker. Ashley, you're on the air. You've got 1 minute
Hi.
and 15 seconds.
Sounds good. Thank you.
Okay, proceed.
Ready to go. Okay. Hi, my name's Ashley, and I'm speaking as actually a healthcare professional, but also a mother and somebody who, I like to say that I really don't have a stake in this because I don't work in healthcare currently, and I may never need to again. But I like to say that, over the years, watching, watching people come in, and employers, going through the process and being a person who has had to go through employee health and things like that, I've run into this issue, and so I'd like to say that at a very basic level, this really is a bodily autonomy issue, and then I'd like to touch on why do we have HIPAA? So we keep healthcare or health records private for a reason, and so why now are we going to put give somebody the access to this kind of information that's really supposed to be private? And it's becoming the norm that we are talking about this amongst friends, family, and then, in the workforce. And I really this stuff it's becoming the norm, and it's really fueling people to become aggressive towards those that may not follow a typical Western med life. And so, why is, this different from HIPAA, and why are we allowing people to be privy to this kind of information? And why is this why could this become an exception? And so, when we look at this information, we want, employers want to be, they want their workers to be healthy and robust and, not put the rest of their workers in harm's way. And so I think that we should be saying, well, how do we do that?
Ashley, are you still there? I guess she's gone. Ken? Ken?
Yes.
You're on the air. You've got 1 minute and 15 seconds.
1 minute, 15 seconds. Okay, thank you, guys. I appreciate this bill, the people that did originate this. So I'll try to keep this as simple as possible. So, as much as I do appreciate this, of this bill, at the same time, I do find it kind of disturbing that an act like this, a bill like this, needs to be emphasized with procedures to battle something that we already have protections for in the first place. So, it appears that we have lost our way, and this past year's overstepping, tyrannical kind of actions and behaviors have put this in a greater spotlight, unfortunately, more than ever before, or maybe fortunately. Nothing in my experiences supersedes the Bill of Rights. It is supreme, and its violation is criminal. So I hope we all look at that in that concept. There have been, as we all know, exhaustive and strenuous efforts into the development of a system that we were structured to operate under, with the checks and balances that would guarantee to provide protections for peace, freedom, and prosperity. With the absolute and most vital of all assets to be protected was, in fact, liberty, and still is in this great country that we live in today, to this day, and hopefully that we all still consciously want to operate under. So, with the those serving in government would not violate the rights of the population, the citizenship. The founders knew what they were talking about, yet many pay very little attention to the things that were done back then and that we have evolved into today, it seems.
Ken, your time's up.
Okay. I appreciate it.
Thank you.
Thank you, guys.
Heidi Krantz. Heidi, you're on the air. You have 1 minute and 15 seconds to testify. Heidi? Heidi, can you hear me? One more. Heidi? Well, we've got a moment waiting for the next caller. We have two reps here, Representative Batista and Felix. Would you like your presence and your votes recorded? Jose? Okay. Madam Clerk? Heidi?
Yes.
You're on the air with the House Judiciary Committee. You have 1 minute and 15 seconds to testify.
Thank you. As a private citizen and mother from South Kingstown, I strongly support this legislation. Many of you defend a woman's right to choose abortion. As a woman, I would like to express that the right to choose also includes other forms of medical care. For me personally, a vaccine is an unwanted procedure, a violation of my physical boundaries, and I ask you to please protect my right to say no. Vaccines have broader unintended consequences than just the risks or benefits from a particular disease. For example, there are mental health effects of vaccinating people against their will, causing them to lose personal agency and to feel that their bodies do not belong to them, which in turn can lead to a greater risk of sexual abuse. The people who choose not to be vaccinated in the face of strong public pressure have bona fide personal reasons. Each person deserves the right to choose what is right for their own body. Thank you.
Thank you, Heidi. And our last witness. She was our last witness? Okay. Well, that concludes testimony on House Bill 61. No, wait a minute. Hang on a minute. That's House Bill 5989, and that concludes our calendar as well. I want to thank the members of the committee that stuck it out, and the staff members did a great job, as well as legal counsel. What's that? Oh, yes. There's been a lot of talk tonight, and there's been some concern on my part, and I've discussed it with the vice chair. I don't want anything, and I think the sponsor agrees with me, nothing that we've heard tonight should take the place of making your own independent decision to go and get a vaccine. The Center for Disease Control, as far as I'm concerned, is the doctor for the United States of America, and that if they're still recommending it, then everyone should follow that recommendation. This is not about getting a vaccine. It's about a choice as to whether you choose to get one or not. I don't think anything about tonight should influence you one way or the other about your choices. So, with that, do I hear a motion to adjourn?
Motion to adjourn.
Second.
All those in favor signify by saying aye.
Aye.
Opposed, nay. The ayes have it. Thank you.
Stay safe.